Hello, and welcome to Bird and Birds A New Era, a podcast where we unpack the most transformative changes to UK employment law in a generation, the Employment Rights Act 2025. The Act is a vast framework of enhanced rights, touching almost every aspect of the employment relationship. It represents a fundamental reset of the balance between employers and workers in the UK. Whether you are a business leader, HR professional, line manager, or employee, this series aims to break down the key changes, explain the practical implications, and help you understand how to stay compliant and prepared in the months ahead. I'm Olivia Baxendale, a knowledge lawyer in Bird and Bird's International Employment Team, and today I'm delighted to be joined by two colleagues, John Goldsworthy, a partner in our team, and Harry Ferguson, an associate in the team. Today we're focusing on enforcement, specifically the new Fair Work Agency, what the extension of employment tribunal time limits means in practice, and how all of this is reshaping the litigation landscape. These are changes that are already starting to bite, and there are some practical implications that we hope to bring to life today. So, Harry, let's start with the Fair Work Agency. A lot of people have possibly heard the name, but may not fully appreciate what it is or maybe where it came from. Could you set the scene for us?
Yes, thank you, Olivia. The agency was established on the 7th of April 2026 under the Employment Rights Act. The policy intention here is for it to operate as a single place where workers and employers can turn for help. It's replacing a system of state enforcement that has been described as fragmented and inefficient. The agency brings together the existing enforcement functions of four separate bodies under one umbrella. HMRC for the national minimum wage, the Employment Agency Standards Inspectorate for agency workers, the Gangmasters and Labour Abuse Authority for gangmaster licensing and labour exploitation, and the Office of the Director of Labour Market Enforcement. Previously, most employment rights were enforced by individuals presenting claims to an employment tribunal. The new model changes that. The agency brings proactive state led enforcement into the picture alongside the individual claims route.
Thanks, Harry. And John, looking at the bodies that the agency is replacing, is there anything in their history that gives you pause about how the agency might evolve over time?
Yes. So if we look at an example of the Gangmaster and Labour Abuse Authority, this was integrated into the Home Office in 2016, and there was a shift to immigration enforcement, which was perhaps unsurprising given the Home Office's wider remit. As such, whilst there were increased referrals, expert and labour organisations estimate that reports actually dropped from migrant workers who were afraid to report exploitation in view of fear of repercussions from an immigration perspective. And that's the opposite of what the agency is supposed to achieve. The Institute of Employment Rights has flagged this as a live concern, and as the agency beds in within government structures, watching its enforcement culture develop will be important, particularly for employers with migrant workforces. The Institute has specifically flagged the worry that over time enforcement priorities shift away from protecting workers and towards other government objectives, and that's a risk worth monitoring closely.
And there is also an interesting piece of research the agency published in May this year called the Working Lives Report, which found that 1 in 7 workers are affected by non compliance with employment laws within the agency's remit. Harry, what does this tell us about the scale of the problem the agency has been handed?
Yes, so over the 2 years to summer 2025, 14% of UK workers experienced at least one breach of core rights now within the agency's remit. For example, related to national minimum wage, itemised payslips, or written particulars. If we zoom out further here, 7 in 10 workers experienced at least one harmful practice, whether unlawful or not, representing an estimated 26.6 to 28.7 million workers. The report's most striking conclusion is that the scale of non-compliance undermines the conventional view that rogue employers are the exception. Non-compliance is widespread, regardless of employer intent. So for anyone listening who assumes this does not affect them or their business, the data does suggest otherwise.
So the problem is significant. John, does the agency actually have the resource to match that scale, do you think?
Well, I think that's the central tension. By 2025, the ratio of frontline inspectors to workers had fallen to one inspector for every 51,000 workers, against an International Labour Organization standard of at least one per 10,000. It's believed the agency currently has around 600 inspectors across the whole country. By way of a useful comparison, under the Health and Safety Executive, reports suggest that the average workplace can now expect an inspection less than once every 50 years. If the agency follows a similar trajectory, its deterrent value is going to be extremely limited in practice. The agency does have an increased budget of 60.1 million for 2026 and 2027, which is up from the combined 47.4 million of its predecessor bodies. So there is more resource. Whether that's sufficient given the expanded remit is a genuinely open question. The agency has been set up with an advisory board made up of trade union, employer, and independent expert members. And that shows that it values insights from businesses on the ground about how to make it easier to comply and to achieve quick resolution and how workers can best understand their rights, meaning the agency can hopefully target its resources where it most matters.
Thanks, John. Now let's maybe get into what the agency can actually do right now. Harry, what enforcement tools are already in force and what is still to come?
Well, as already mentioned, the agency was established in April this year, and there is a phased approach to bring the various aspects and parts of the agency together. The rest of 2026 will be a startup year, and I think we're unlikely to see much impact or difference until next year. Although, that being said, a few of the agency's powers have been live since April. The key ones to be aware of include the power to investigate and require individuals to attend meetings, answer questions, and provide documents or information, the power to enter premises, to inspect documents or access computers and equipment. The agency can also issue labour market enforcement undertakings and orders where it believes an offence has been committed and require employers to take specific steps. It can also issue a notice of underpayment plus a financial penalty of 200% of the underpaid amount, up to a maximum of £20,000 per individual. That currently relates to national minimum wage, although the government has acknowledged that the transfer of national minimum wage enforcement to the agency will take time, with this year being a transitional year and full transfer expected by April 2027. A few powers which are not yet enforced but are expected to come in next year are the powers to bring tribunal proceedings on behalf of a worker, to provide legal assistance in employment related proceedings, and to recover enforcement costs from employers. Also, holiday pay enforcement is expected to commence in 2027. So employers do have a window to resolve this in the meantime if there's any issues, but it is fast approaching.
Thanks, Harry. You've highlighted there how the agency is clearly taking a phased approach. I think focusing first on enforcing existing rights and looking maybe at sectors with systemic non compliance. And the rationale for phasing in holiday pay compliance, for instance, in 2027, seems to be to allow the agency to be shaped in the right way first with that compliance first mindset, but with a strong arm for serious or serial offenders. Now, given that vision, practically, what should employers be doing right now, John?
Well, there's a number of things they can do. I think first and foremost, audit compliance, focus on national minimum wage calculations, holiday pay, and payslip accuracy. The working lives data shows non-compliance is widespread, and so demonstrating compliance before an investigation is far better than trying to put things right under pressure. Get your records in order. So from the 6th of April this year, employers are legally required to maintain adequate holiday and holiday pay records for up to 6 years. Digital record keeping systems need to be capable of producing contracts, pay slips, and other attendance records in a portable and legible format. The agency's investigatory powers are already in force in relation to that. Companies should strengthen internal grievance processes. As you mentioned, the agency's approach is compliance first, not automatically punitive. It will focus on advising and providing guidance to secure compliance rather than immediately reaching for sanctions. But the best outcome for any employer is resolution before a matter escalates to any potential agency investigation. So ensuring you have robust internal grievance processes is going to be key to helping that as a first line of defense. And finally, train your management and HR now. The agency's powers to compel individuals to attend meetings and produce information or documents is already live, so staff need to know how to respond appropriately. So training managers is important, as well as having internal protocols and processes in place to deal with this if it kicks off. And even if the agency is under-resourced in the short term, a notice of underpayment at 200% per individual is a significant financial exposure and a significant incentive to get it right.
Thanks, John. And those practical tips apply whatever sector you operate in, as the aim of the agency is to be sector blind. So it intends to take a consistent approach to non-compliance regardless of sector or region. Now let's move on to tribunal time limits, a change coming very soon that I think has been somewhat overshadowed by maybe other headlines. Harry, can you talk us through what is changing and when?
Yes, well, currently, most employment tribunal claims must be brought within 3 months of the act complained of. This covers unfair dismissal, discrimination, detriment, and whistleblowing. The Employment Rights Act extends the time limit to 6 months, and that's expected to take effect from the 1st of October 2026 and to apply to all employment claims. We expect this will apply to causes of action on or after that date.
And is there a related change to the ACAS early conciliation period that works alongside this? Could you maybe explain how the two pieces fit together?
Yes, the stop the clock rules, which pause the time limit during ACAS early conciliation, are unaffected. As a reminder, since the 1st of December 2025, the early conciliation period may now last up to 12 weeks, extended from the previous 6 weeks. The two changes are clearly designed to work in tandem. We have a longer conciliation window and a longer backstop limitation period. The overall runway from acts complained of to tribunal claim being issued has materially widened on both sides. For ACAS, this means pre-issue conciliation is going to be longer and more substantive. This could be an opportunity if both sides engage in good faith, but it could equally be a risk if the extended window simply delays the inevitable.
Absolutely. And what do you think this means for claimants and for employers?
Well, I think firstly for claimants, this should reduce the need to issue claims defensively, simply to stop time running whilst workplace resolution is still being pursued. This is particularly relevant in discrimination and harassment cases, in dismissal cases where internal appeals are still ongoing, and also for vulnerable workers who might need more time to take advice. Whereas for employers, the window of exposure stays open for longer, which therefore creates some uncertainty. A claim that you thought might have gone away might not have actually gone away. An unresolved exposure sits on the books for longer. Document retention policies and assessment strategy need to reflect this. Ultimately, for both sides, the longer time limit means that a final hearing in any potential claim may take even longer to get there, adding to the existing delays and backlogs that we're seeing in the tribunal system. Early and proactive evidence gathering will therefore be important to avoid any impact on witness evidence. Preserving statements and documents at the point of dismissal or disciplinary action will be crucial, not just when the proceedings arrive.
Thanks, Harry. And John, turning to you, pulling all of this together, we have the Fair Work Agency, we have the extended tribunal time limits, the extended conciliation period. What is your overall view on the litigation landscape on the horizon?
Well, I think first and foremost, we're going to see more claims and longer tribunal delays. Extended time limits remove one of the practical barriers that can prevent some claimants from ever issuing proceedings. The Working Lives data tells us that millions of workers have got unresolved rights violations. However, more accessible enforcement routes could very well translate into more claims reaching the tribunal, putting even more pressure on an already overburdened system, and most probably even longer delays, particularly when you look at it in parallel with other legislative changes, such as the reduction in unfair dismissal qualifying periods, which I think are going to open up other potential claims for a significant number of employees. We've got a new enforcement channel running in parallel. Once the agency's power to issue proceedings comes into force, there'll be state enforcement routes alongside the individual tribunal routes. However, the agency can only bring tribunal proceedings on a worker's behalf if the worker is not going to bring proceedings themselves, which creates an important practical interaction that employers and claimants will need to navigate. Parallel processes for employers. An employer facing an agency investigation can simultaneously be managing an individual tribunal claim on the same underlying facts, and managing both processes with different time limits and different procedural rules is going to be a real operational challenge.
It certainly will, and I think it will also be interesting to see how the agency works alongside ACAS to ensure there is alignment and to avoid that situation where an individual is in a dispute resolution process with both ACAS and the agency about the same dispute.
Absolutely. In fact, the agency's strategic steer, which was published on the 7th of April this year, expressly directs that it develop a joint operating model with ACAS. And the government's vision is for a single digital front door, a unified point of access to both conciliation and enforcement. And as that model develops, an ACAS early conciliation notification and an agency investigation could increasingly become part of the same picture rather than separate, unconnected processes. Employers who engage constructively and resolve disputes quickly are going to be well placed. Those who do not may well find that an unresolved individual complaint escalates not just to the tribunal, but it triggers a broader agency look at systemic non-compliance. What starts as a single grievance about holiday pay could well open the front door to a much wider investigation, and that's a significant shift in the risk calculus.
And we all know, as you've mentioned, that the tribunal system is already under significant strain. So, layering in a new state enforcement body with its own parallel investigatory litigation powers adds a further dimension. And I think this is genuinely uncharted territory.
Yes, and we've already touched on how the agency's approach is described as compliance first, but that doesn't mean it's toothless. An employer who refuses to cooperate with an agency investigation or who fails to comply with a labour market enforcement order faces criminal liability, so the stakes are very much real.
The agency's first statutory enforcement strategy is due in April 2027, and that's the document that's going to tell us where it intends to focus its resources and signal its enforcement culture. And it's also the moment when the joint operating model with ACAS will take concrete shape. For employers and advisors alike, that's going to be the key publication to look out for.
I think we all agree that there is a very clear vision for the agency, and we will just have to see whether the reality meets that vision in the coming months and years. The role for ACAS may also evolve in the future as a result, and I think it's clear that we are all expecting the extended tribunal time limits to have a real impact on the struggling tribunal system. Thank you, John and Harry, for a great discussion.
Thank you.
Thank you very much, Olivia.
If you found this episode useful, please subscribe, share it with your network, or visit twobirds.com for further information. Thank you for listening to A New Era, and we hope you'll join us again next time.